Thank you so much for joining us today. Today's webinar series, we'll be covering Ontario employment law legislative updates. We've got a lot of ground to cover, so I'm going to launch right into it. So as you know, we are Achkar Law. We were first founded back in 2016. Our focus is on employment law, human rights law. We also do workplace investigations. We have a labor law group, as well as our litigation group includes civil and corporate commercial. Today's host will be yours truly. My name is Charles Miller. I'm a senior associate here with the firm. I'm joined by my friend and colleague, Mariel Gerges. She's also a senior associate as well. And so without further ado, here is just a bit of a brief summary of what we'll be covering today. And I must emphasize it is a summary. A lot of these legislative updates that came to full force and effect this year are quite substantial. And we're not going to be able to cover everything today. So what we've done is we've chosen a few select items that we feel are absolutely relevant to you right now. It's not a comprehensive list nor an exhaustive list. To start with, we're going to talk about some of the Employment Standards Act amendments that came into full force and effect earlier this year around end of March 21st, in fact. There were two key changes. The first one is they've changed the definition of an employee to include individuals who are also completing a trial period for a company. Many of us who are a bit older might remember times where we joined a company and we just wanted to get our foot in the door. So we agreed to work for free, just wanted to show our boss the work we could do. Well, those days are gone. Essentially, anybody who's doing work for the company must be paid. Definition of employee to the ESA, especially in Ontario, now includes individuals who are completing a trial period of work, and the ESA prohibits any unpaid trial periods, meaning if someone does work for you, even if you're not sure if you want to hire them just yet, you do need to pay them for the work they completed. Now, speaking of payment, Section 13.6 specifically amends a bit of a nasty situation that we all might have experience with. Specifically, it prohibits employers from withholding, deducting, or if the employee is responsible or has any sort of connection to a situation where a customer leaves without paying or refuses to pay for goods. We may have heard circumstances, especially seen it in Hollywood shows, where you've got a waiter who's done a great job serving dinner or lunch, and then the nefarious customers decide to dine and dash. The angered restaurant owner might then deduct those wages from the waiter or waitress, holding them responsible for being negligent and overseeing the customer. So essentially, in circumstances where we have the dine and dash customers, we might have seen situations where the restaurant owner would have held the waiter or waitress responsible for that, and then insisted that the lost wages or the lost meal bill went under the responsibility of the waitress, and they had to pay it back, or it came out of their tips or came out of their wages. Well, gone are those days. The ESA has amended it that it is absolutely prohibited to actually withhold any of that payment and withhold any of those wages if your employee is responsible due to their negligence or malfeasance for any unpaid goods or service or any unpaid services. There are other methods to hold that employee responsible, going through progressive discipline steps, but you cannot withhold their wages. The next thing we're going to step into is some of the most recent changes to the Employment Standards Act. These ones came into full force and effect June 21st, 2024. The first thing to step into is vacation. Vacation pay is a bit of a tricky area of employment law. It's often an afterthought whenever we're talking about terminating an employee or when we're talking about letting an employee go. And so what these new amendments have gone up is to try to tidy up some of these payment methods. Specifically, if you're going to pay an employee for vacation pay, if you want to pay it alternatively rather than on top of their paycheck, you need to actually have a written agreement between the employee and the employer. So it has to be clear and unequivocal. That does help the employer down the road, so that if the employee has any sort of complaint for how they've been paid, you can point to that document. And any sort of change to how they're paid, any sort of understanding to how vacation pay works, must be in writing. Back in the day, good old handshake and verbal agreement was sufficient, so long as we did a credibility analysis between the employer and the employee. But now the ESA has tightened that up. So now everything needs to be in writing, and everything for even any change to the paycheck, if you're paying them a bit differently, must be in writing and must be clear that all parties agreed to the changes. Again, that might seem like a bit of a hassle for many employers who are used to verbal agreements and good faith agreements. This does keep you safe as an employer. Having everything in writing is best so that if there's any disagreement down the road, you can point to the document. So this is better for both employers and employees. Now, the payment of wages, obviously absolutely critical to the employer-employee relationship. But now, whenever we're dealing with direct deposits, we need to make sure that those direct deposits are managed properly. That means that the account you're depositing into must be in the employee's name, specifically in their choice as well, and accessed only by the employee or another person they authorize. So gone are the days of someone saying, yes, you can put it into my wife's account, or you can put it into my son's account. The account itself must be in your employee's name, and specifically, it must be obvious that it's their account. Other people can have access to the account. Sometimes employees will have shared accounts with their spouse, but they must be authorized. This also keeps the employer safe so that they're well aware that they're paying their employee directly and there's no complaints down the road for who's not getting paid. The account must meet criteria that's established by the government. This is, again, another way to keep you safe as the employer so that all the employee wages is going directly to where it's supposed to go. There can be no accusations down the road that you weren't paying someone directly or you were paying the wrong person. This is a great way to keep things tidy and keep payments safe and secure. The payment of tips got a major overhaul. So the first thing to understand is the tip sharing policy now must be absolutely available to everybody to understand what's going on. So if you've got employers or directors and shareholders who also participate in tip sharing, then the policy for how they get to participate must be in writing, and it must be absolutely established within the workplace so that everyone can see it and review it. And they need to be able to review it even if it hasn't been in full force and effect for up to 3 years. You'll see that in our section, we have to say that you have to keep it in place for up to 3 years. That means that if you have a new tip sharing policy that comes into full force and effect, the old one still needs to be available for at least 3 years so that people can go back and review how that was established. So make sure if you've got a tip sharing policy, it is in writing, it's above board, and everyone can review it. Now, the payment of tips, as we all may recall, used to be a little laissez-faire. Tips sometimes went into a jar and they were distributed as they were. Well, the new administrative changes have tightened up that and provided a little more guidance. And again, as I've said before, this is good for both employers and employees to make sure that everyone knows exactly how this is to be done. The first thing to know is that tips can be paid in cash, check, or direct deposit. So the tips that go into the tip jar can be collected, can be accounted, and then paid out via check to the individuals. Any cash or checks provided to the workplace, tips provided in cash or check must be given in the workplace or another agreed upon location between you and the employee. Great idea to have a policy on this and perhaps some written understanding between all parties. So if you want to mail them their tips, make sure you have that in writing or make sure you have a policy available to describe that as well. And if you're going to actually directly deposit the tips into their account, then just like we said before, the deposit must be in the employee's name. It must be an account selected by the employee, accessible only by the employee or an authorized person, and must meet any prescribed criteria as set by the government. Again, this goes back to what we talked about earlier when you're paying your employees' wages. The same principles for making sure that that account is your employees also applies to tips. And now I'm going to toss it over to my friend and colleague Marielle, who's going to talk about the legislation amendments that are about to come into full force and effect under the Working for Workers Act 5. These changes have not yet received royal assent, so Marielle is just going to walk you through what to expect. Marielle, thank you so much. You can take it from here.
Thank you, Charlie. And you mentioned something extremely important, which is that this legislation has not yet received royal assent. So while we will briefly go over some of the proposed changes, it is possible that when they do become law and become enforced, it might be a little bit different than some of the contents in our slides today. First, no one is surprised to hear about the increased minimum wage. Ontario is expecting to raise its minimum wage from October 1st, 2024 to about September 30th next year to the following: $17.20 per hour generally, or $16.20 per hour for students. And this is quite a big jump from the previous $16.55 generally and $15.60 respectively. This will actually make Ontario's general minimum wage the second highest in Canada, right behind Yukon. It's important for employers to follow these new minimum wage requirements, as minimum wage is an employment standard guaranteed under the ESA or the Employment Standards Act, and there can be very serious and expensive consequences for an employer that fails to follow those minimum standards. So I mentioned that it can be very expensive to breach the ESA. Let's talk about how expensive it is, because this new act is looking to make it even more expensive. Currently, the fine is up to $50,000 for individuals, and this act attempts to change the maximum fine to $100,000 for individuals who violate the Employment Standards Act. The ESA currently has a three-tier fine structure for some violations within a 3-year period. So for the first offense, it's about $250 per employee that's affected by the violation. And for the second offense, $500 per employee affected by the violation. Fines for those who violate the ESA more than 3 times in a 3-year period for certain violations can be fined up to $5,000 per employee affected by the violation. This is a significant jump from the previous maximum of $1,000 per employee affected. The 5th Working for Workers Act also proposes changes to Section 50 of the ESA, which relates to unpaid sick leave. Currently, an employee who has been employed for at least 2 weeks is entitled to an unpaid sick leave of absence if it's due to personal illness, injury, or a medical injury. It doesn't necessarily need to be on the job. The Act does provide an employment minimum of 3 days in a calendar year for this type of leave. Keep in mind, this is just the employment standard minimum. An employee's contract might offer them a little bit more, so check that contract first. An employer can require an employee to provide evidence reasonable in the circumstances to provide the employer who is entitled to this leave. The 5th Working for Workers Act proposes to add in a giant caveat actually to this requirement for medical evidence. Previously, an employer just needed to request evidence reasonable in the circumstances, but now the proposed change actually prohibits an employer from requiring a certificate from a qualified health practitioner as evidence for the purpose of this leave. And qualified health practitioner is defined as a physician, registered nurse, or psychologist, or a member of a prescribed class of health practitioners, which is quite wide. Employers are still entitled to ask for reasonable evidence, but they are no longer allowed to ask, when these amendments come into force, for a medical certificate. One of the biggest changes coming under this Working for Workers Act is the requirements for employers who publicly advertise jobs. For job postings that are publicly available, employers cannot post requirements related to Canadian experience, with a few very limited exceptions. So this would be, for instance, where an employer tries to hire a candidate, and instead of specifying they want 2 years of Canadian experience, they would need to essentially remove the word Canadian and view all experience equally, again, with very limited exceptions. For employers that rely on AI or artificial intelligence during the hiring process, so this includes screening, assessing, or selecting potential applicants, would also need to disclose the use of that AI in a new job posting. Employers will also be required to post the expected compensation or range of compensation for the position in public advertisements, again with very limited restrictions. Those are 2 major changes within the job posting landscape. The Act also does change the definition of employer to include prospective employers. So this does also change the obligations of prospective employers and allows the definitions to be used interchangeably here. Employers, as Charlie mentioned, have very extensive record-keeping requirements under the Employment Standards Act as well. And with job postings, it has now been expanded to that too. So employers are required to keep copies of publicly advertised jobs for 3 years after the post is removed from viewing by the general public. There's changes to the Occupational Health and Safety Act as well. So with the increase of virtual workplaces, it's not much of a surprise since the pandemic that Ontario laws are trying to keep up with the new workforce here. It does also expand the employer's obligations to recover remote workspaces. Ontario has updated the definitions or is working to update the definitions of workplace and sexual harassment to also include virtual interactions. OHSA is the base legislation in Ontario that provides employers are required to provide employees with safe working environments, which includes environments free from harassment and bullying. And these protections will be expanded under legislation to expressly include remote workspaces, even if the employee works from home. So OHSA does apply to telework in private residences. There's some other miscellaneous amendments that have been proposed recently, including the obligation to provide clean and sanitary washroom facilities, changes to youth apprenticeship programs, introducing a new stream called Focus Apprenticeship Skills Training, or FAST, which helps grade 11 and 12 students engage in more apprenticeship opportunities through cooperative credits. It also requires the registration of temporary help agencies to have a license to operate. This aims to prevent the exploitation of vulnerable newcomers to Canada who may not be aware of employment standard minimums. The Ministry of Labour has been quite vocal about cracking down on what they have labeled as criminals who attempt to prey on those who are vulnerable. The idea is these temporary help agencies, with the requirement of these registrations, new workers will be able to look and see who is licensed, who isn't, and who would be willing to assist them in ensuring their employment standard minimums are met. Recent changes also look to expand medical coverage for firefighters. So it now includes presumptive occupational cancer coverage for firefighters as part of their role. They are now going to be assumed that this is part of their occupational hazards as part of the job. There's also major requirements for construction workers now. For large job sites, they will be required to provide menstrual products at projects expected to last 3 months or more with 20 or more workers. This includes sanitary items to ensure cleanliness and hygiene, and products are to be available at locations offering reasonable access and privacy. And these amendments are looking to be enforced from January 1st, 2025 onwards. We want to recap some of the takeaways that apply not just to the legislative proposed changes that we've discussed today, but in general with all of our webinars. It's extremely important to have a lawyer by your side to monitor changes to relevant laws. A lot of the changes that we've discussed today, as Charlie mentioned, came into force earlier this year, some as recent as a few business days ago, and some that are not yet in force. The reality is employment laws are changing all the time. There is no substitute for tailored legal advice. To have a lawyer to regularly review your employment contracts and internal policies, as well as keep you afloat of any changes that could affect your specific workplace. We always recommend an annual review of operation practices just to make sure they conform with new legislative changes. And if any recent changes are made that could affect the language of your employment contracts or policies, we're by your side to help make sure that your business conforms as soon as possible, because as we've discussed earlier today, some of these violations can add up in terms of cost.
Thank you so much for that, Marielle. Now, I did say that we probably wouldn't have time for questions, but it looks like we covered a lot of ground pretty quickly. So we do have a bit of room to answer some questions that came in. One thing we have here, so Marielle, you are in the hot seat. I'm going to throw a question your way. Can a medical certificate be requested if the time off is paid under an STD program? Our current STD is self-insured that pays for it for the STD, providing it is properly supported by the completion of any physician's report. And the wait period is set at 7 calendar days. So again, can the medical certificate be requested if the time off is paid under a short-term disability program?
And the answer to that is yes. The unpaid leave under the Employment Standards Act is actually different than leave through short-term disability through an insurer. So as long as that insurer does require that medical evidence, yes, it will be required for an employee to take advantage of those benefits. The Employment Standards Act only provides a minimum of up to 3 days for unpaid sick leave. However, for short-term disability, which could last up to 3 months, the employee would be looking at taking a paid sick leave if available through their benefits.
Thank you. And in the same vein, once the legislation is passed regarding medical notes, will employers still be able to request medical notes from employees after they have used their 3 days of sick leave under the ESA, especially keeping in mind some employees who have a habitual absence throughout the year due to mysterious illnesses?
One thing I want to point out just very quickly is that the Employment Standards Act provides minimum entitlements. So 3 days is the minimum an employee is entitled to for unpaid sick leave. If the employment contract offers, for instance, up to 2 weeks unpaid sick leave, the employment contract is allowed to offer more than what the employee is entitled to. So take a look at the contract first just to make sure that the 3-day benchmark is correct in this specific situation for this employee. With respect to medical evidence going beyond that minimum period, I would say have a lawyer involved sooner rather than later, because what we're entering, especially with employees who habitually take sick leave, is discrimination based on disability. There may be a more proactive obligation on the employer to inquire and see whether any accommodations need to be made or what is actually going on with the employee.
Thank you for that. And building off of what Marielle said there, it is very important to have an employment lawyer there guide you through this. Employers have quite the burden in terms of almost need to be absolutely perfect to avoid any sort of reprimand of the ESA or the Ontario Labour Board. There's almost a call to be near perfect when it comes to the way you deal with employees. And as Marielle mentioned, employment law changes constantly. In fact, it evolved 3 times this year, March and June, and once Working for Workers Act 5 passes, another time as well. So keep up to date. Have a lawyer is absolutely important. One more question for you, Marielle. We noticed that with the minimum wages, that it said that an end date was in September 2025. Why is that?
They tend to change year by year as Ontario has recently moved into matching minimum wage with inflation. So the idea is to check and see every year how much inflation is and match the minimum wage accordingly.
We are at the end of our webinar series for today. We covered a lot of ground, especially some legislative ground that's going to leave you with more questions. And feel free to email myself or Marielle for a consultation if you have any further questions or something in the workplace has come up that might be impacted by these new legislative changes. Once again, thank you to everybody who attended today.